On May 5th, United States Trade Representative Katherine Tai announced that the United States would support a waiver of IP protections on COVID-19 vaccines. IP waivers are being discussed at the World Trade Organization, or WTO, after being proposed by India and South Africa, two countries that have been hit very hard by the pandemic. Numerous countries and many commentators and organizations also support a waiver. The purpose of the waiver is to ensure a country would not be found in violation of TRIPS, an international intellectual property treaty that requires member countries to provide and enforce a certain minimal level of intellectual property. Patents come with a period of exclusivity, wherein the patent holder has the right to exclude others from making, using, or selling the patented invention without permission. TRIPS requires its member countries to provide patent protection and the means to enforce those patents. TRIPS also allows for compulsory licensing, an exception to this usual right of exclusivity. So long as the patent owner is provided adequate remuneration, in an emergency, a country can authorize someone other than the patent owner to make and use a patented invention without the permission of the patent owner. Because TRIPS already permits countries to grant compulsory licenses of patented technology in cases of emergency, the understanding is that the waiver would likely go further. For example, maybe requiring a transfer of unpatented know-how from patent owners to licensees. Historically, the United States has been rather vigorously opposed to compulsory licensing, and has even sought trade sanctions when other countries have authorized or even contemplated compulsory licensing. The United States has, at least on the international front, been supportive of protecting intellectual property rights. The fact that the U.S. Trade Representative has signaled support for a waiver that is, in all likelihood, going to be broader than compulsory licensing and potentially more harmful to innovative American companies represents a significant shift in policy. Intellectual property advocates are concerned that the proposed waiver undermines IP rights. For instance, what happens if the company that developed the vaccine is not able to recoup the development costs associated with getting the vaccine to market in the first place? And while the waiver is intended to only be enforced during the pandemic, any know-how or trade secret information that is required to be transferred would never be able to be reclaimed by the innovative company. That asset would be forever lost. These and other actions that devalue intellectual property rights could have some widespread negative impacts on pharmaceutical companies going forward. The necessity of the waiver has also been questioned based on promises from companies to not enforce their COVID-related patents, the amount of time that will pass before the waiver is even approved and implemented, and after that, the amount of time that would be required for factories and infrastructure to be put in place to manufacture and deliver vaccines. For these reasons, the waiver of IP protection for COVID-19 vaccines has been called largely symbolic. Is the waiver the right solution to the problem of getting vaccines to people who need them? Is the argued weakening of IP rights worth the waiver, especially given the significant questions about whether the waiver will even make a difference? Should the WTO have the power to decide whether and which patents get enforced? Join the conversation in the comments below.